right, ladies and gentlemen, we are back on. It is 1:15, and I am very pleased to introduce our next session. We have with us Commissioner Hester Peirce from the United States Securities and Exchange Commission, as well as Professor Eric Chafee from Case Western Reserve University School of Law. So with that, Professor Chafee.
Thanks. So I want to take a quick minute to thank the division for partnering with Case Western. It's been wonderful getting to know all of the members of the commission, or the division, excuse me, over the years. Certainly, it's great how much the blue sky regulators in Ohio are willing to share in terms of their wisdom with a professor, and then in addition to that, knowing that they're on guard here to make sure that investors are protected. So I have the pleasure of introducing Hester M. Peirce, who was appointed by President Donald J. Trump to the U.S. Securities and Exchange Commission and was sworn in on January 11th, 2018. Prior to joining the SEC, Commissioner Peirce conducted research on the regulation of financial markets at the Mercatus Center at George Mason University. She was a senior counsel on the U.S. Senate Committee on Banking, Housing, and Urban Affairs, where she advised ranking member Richard Shelby and other members of the Committee on Securities Issues. Commissioner Peirce served as counsel to SEC Commissioner Paul S. Atkins. What's that guy doing now? She also worked as staff attorney in the SEC's Division of Investment Management. Commissioner Peirce was an associate at Wilmer Cutler and Pickering, now Wilmer Hale, and clerked for Judge Roger Andewell on the Court of Federal Claims. Commissioner Peirce earned her law degree from Yale Law School, and some other institution gave her bachelor's degree at Case Western Reserve University. So I want to welcome back Commissioner Peirce to Case Western. We're so grateful that you are going to join us today and share your wisdom today with us in terms of this discussion. To start off, I'm going to say that I'm constantly impressed by people who I meet who graduated from Case Western in this institution. The reason for that is because my wife tells me that I have to say that regularly. She's actually an alum. And actually, it's some weird times. Strangely enough, we're just driving in the car and she makes me say that. With that being said, that's certainly true, and it's certainly true in this case. Clearly the Crypto Task Force, which you lead, has been incredibly busy this year in terms of what's been occurring on the federal level, in terms of stablecoin, market structure legislation getting passed, the SEC and CFTC roundtables galore, interim guidance, and then certainly all of the listening sessions that you've done, both in regard to the roundtables and in regard to the trekking across the country. I do want to start out with this question, then. In regard to being on the SEC, obviously you started out during the Trump administration, and then with the Biden administration taking over, you spent a lot of time being a voice of dissent, meaning that there were a lot of instances where the regulatory agenda felt as though it didn't necessarily fit with your own views of where securities regulation might be headed. And my question is with the direction that we've headed in regard to crypto regulation, how does it feel at this point to be, winning, so to speak? And in regard to thinking about that, how does the role that you're playing interact and relate to the other individuals at the SEC in terms of, both of those ways of relating to the commission?
Well, first of all, thank you, Eric, for having me here. Thanks to Andrea and your team also for putting this together. It's great to be here. I do have to give you my disclaimer, which is that my views are my own views as a commissioner, not necessarily those of the SEC or my fellow commissioners, even though I may now more often be in the majority. Doesn't mean that I always am, and I don't speak for them. But I think it is really nice having Commissioner, my old boss, Commissioner Atkins, is back as chairman. Commissioner Ueda, who was acting chairman before Commissioner Atkins got there, he also worked with me when I worked for Commissioner Atkins. And so the three of us know each other very well, and I think that's quite helpful in aligning how we approach things. We really see things similarly, and we also know each other's strengths, and I think that's quite helpful. Even during the years of dissent, I think the goal was always to invite people within the commission and from outside the commission to help us think through difficult issues, because reasonable minds can differ on how to approach issues. And so I think it really is important to make it a conversation, and that was really what I was trying to do with my dissents. And so I still think that that's really important, getting that outside input. It certainly does feel better to be in a world where an industry isn't being picked out and vilified for the sake of it being an industry that some people don't like, right? So I think that was not an appropriate regulatory response. I think it set a lot of really bad, maybe established bad habits on both sides, in the regulatory world and also in the in the industry itself. And I think we'd be in a very different place if we had approached it differently. And so, yes, I'm happy that we're not doing that anymore, and I'm happy that there's an open mind in terms of regulation. But I don't think that means that we have an easy job, because there's still a lot of really difficult questions to answer. And I think we just saw in the last panel, there are a lot of really bad things that are happening still. And so those things are still quite heartbreaking, and we've got to figure out a way to try to stop that bad activity from happening. So there's always something to be depressed about, even when you're in the majority.
So let me ask you this: why such a focus on crypto? I mean, I think one of the reasons might be that under Jay Clayton's leadership, there was an emphasis on cybersecurity because of the Edgar data breach, and ultimately crypto is connected to technology. There's also a newness, but why does the SEC spend so much time thinking about it? Why is it doing so much thinking about it now?
I mean, that is a fair question, because we have a lot of other things that are very important and that we really need to spend time thinking about. So the way I look at it is, we need to spend a fair amount of time right now, because we've got to establish some regulatory parameters within which people can operate. But I mean, at the end of the day, it shouldn't be, and this is why I say the task force that I'm leading, it's not intended to be a permanent fixture at the SEC. This is a moment in time where we're working on establishing these regulations, and then once we've established them, the work will pass into the normal divisions at the SEC, and they'll end up doing that work without having it be a focus, crypto specific. And I mean, I think we used to have an Office of Internet Enforcement, right? And this kind of goes back to what you were saying earlier, Seth. Like, that used to be a thing, but that wouldn't make sense now, because everyone uses the internet. And I think it's going to be similar with crypto. It will be integrated into a lot of other things that happen. I talked to traditional mainstream financial firms that are thinking about how they can use, whether it's stable coins or use a blockchain to do something, or tokenize bonds or equities. People are very interested in seeing what the technology can do for the traditional markets, and so we will see integration. And so it's really a moment in time, I would say.
So you mentioned this in terms of the comment you just made. I mean, under the Biden administration and Chair Gensler, it seemed like there was a lot of regulation going on by enforcement under interim Chair Ueda and then Chair Atkins. It seems like there's been a lot of staff pronouncements, a lot of guidance. In terms of thinking about that, I mean, that creates a lot of fluidity in terms of what's going on with regulation, what's going on with enforcement. Is that a good thing? Is it a bad thing in regard to where the crypto industry is, where the technology is, in your opinion?
Well, I mean, the guidance, I think, is a good thing. It's something that I've been calling for a long time. And even though it's coming out at the staff level, it does help people to think through issues with the assistance of, here's how the SEC staff, who are very smart people who have thought a lot about these issues, here's how they're thinking about these issues. So I think that that's helpful. But you're right. I mean, now we're in a different world than we were last year at this time. We have really changed, done a 180 on how we think about crypto regulation. And one of the reasons that isn't good is it's really hard to build a business if every 4 years the regulatory policy is going to change. And I think that's kind of what you're getting at. We really need to be able to give people consistency over time. And so, I mean, that is something that we're striving for. We're hoping to move toward regulation. We've so far done a lot of guidance, but we really are hoping to get regulation out the door. The fact that we're in a government shutdown is not particularly helpful to that, because I can work, but there are very few other people who are able to work right now at the SEC, and so writing rules is sort of on hold for now. And then there are the legislative efforts, which were mentioned earlier today, and those efforts will also help to bring consistency over time. It's much harder to change once you've got legislation in place. So I hope that will bring us some certainty, and then I think people can feel comfortable building their businesses in the U.S. But the other piece I say is that even if we don't get regulation or legislation, the best thing the industry can do is to build useful things that people want to keep. And so if we do that, then I think it's much less likely that a new administration comes in and says we're gonna use regulation to tear this industry apart as we did before.
So a couple of questions there. One related to the now and one related to the future. And I have a personal interest in compliance because we have a compliance program here that I head. For companies that have built compliance programs around the previous regime's expectations, what's the transition path? I mean, is it one of those things where they should dismantle everything and just accept what's going on now with the crypto task force? Should they expect that there's going to be some sort of shift when, ultimately the next regime takes over the next administration, better put?
Yeah, well, I mean, I think a lot of people were in a holding pattern, and so I don't know that compliance programs really were built around the last regulatory regime, because the last regulatory regime said, if you build something really, really cool and interesting, we'll probably come along and sue you for it. And so your best bet is to build something that is useless and ephemeral, and then maybe you'll be able to avoid it, or go outside the US and build it there, and then you can build it according to whatever rules you want. And that, I mean, unless you go to a more regulated jurisdiction, but the choice of some people, some very prominent examples I think we can all think of, things happened outside the U.S. and that was not to the benefit of anyone. So I think now it is still difficult for someone trying to build in this space, because while we've provided some guidance, there's still more that we could do on that front. And so people are still hungry, compliance folks are still hungry for guidance about how we're thinking about these issues. The question of where the line between a security and a non-security is still one that is difficult for people. And so I think, stay tuned as we work on regulation. Come talk to us, tell us what your issues are, where the problems are that you face. And then I hope we can get to a point where a compliance person with a question can actually just call up the SEC and we can work through those issues together. But there's certainly still work to be done. I appreciate that.
So the question about the future, and you mentioned rulemaking. I mean, how do you see SEC rulemaking play out? Does it depend on what happens in Congress? What do you see might be the likely developments there? And yes, I'm a law professor. When I say one question, I ask three.
Well, I think we are looking to see what Congress will do, and we're working with them, providing technical assistance to them. But we have a fair amount of authority already, and so we're trying to use that authority that we have to try to write rules and work with folks who are trying to figure out what the rules are. We also have broad authority to exempt people, and so we're working with people on exemptions as well. And I think whatever we do will fit well with what the Congress ultimately ends up doing. Another piece, you mentioned the CFTC SEC roundtable. We had that a couple weeks ago, and I think it was very evident there that the two agencies at this point are not interested in fighting each other for jurisdiction, but rather figuring out how we can draw clear lines, allocate regulatory authority where it makes most sense to allocate it. And then I think we really need a process whereby if someone has a product they want to bring to market and they have no idea which regulator is going to regulate, they should be able to come to both regulators at one time and work through that issue. So I think that can also be helpful, and that's something we can do again without new legislation.
So shifting topics of the Division of Corporate Finance has issued lots and lots of statements and lots of guidance. Why was it and is it important for the SEC staff to get these statements out? Meaning why now? How much actually are the opinions of the staff, and how much are they to be attributed to the commissioners who support them? How are they developed?
Yeah, well, why now is it's too late. It should have been done much earlier. It should have been done years ago, and there were very obvious areas where we could have provided guidance years ago and we didn't. And so my view was when the task force got up and running, one of the things that I wanted to work with staff on was to get guidance out in areas where we could, and where the staff was comfortable providing guidance, and so that's something that we've been doing. You are right to highlight that it's staff guidance. That's not the same thing as commission guidance. Regulatory agencies are all different. I think that's one of the things that law students don't always appreciate. Each agency has its own personality, but it also has its own structure, and we're a commission, which means there are typically 5 commissioners, and things pass, whether rules or enforcement actions, by majority vote. And so staff can take positions on things, but those positions are not the same thing as something that's proceeded through a commission vote. But I think it is still helpful for people who are very hungry for an understanding of how the SEC is thinking about things to have staff guidance come out. Staff does work for the chairman, so I think that's a helpful hint of how the chairman thinks about things, although he's actually been pretty outspoken about how he thinks about things directly himself also.
So in terms of all the statements, what's the reaction been in your view? Favorable, unfavorable, mixed? Have the statements produced deal volume? Have they brought crypto businesses back to the United States?
Well, I think they've been helpful to a lot of people, and I've heard people have told me as much. There are other people who think they're not right. There are always people who are going to be unhappy about things, and especially in crypto, you've got lots of people who think lots of things and don't hesitate to say it, so we get some negative commentary too. In terms of whether it's brought deal volume back, I don't know that I can attribute the return to the U.S. and as a direct reaction to a statement of guidance that comes out from the staff. I think it's more the general realization that the SEC is not now intending to use its regulatory powers to shut down an industry, which was the approach that we were taking before. And so it's much more comfortable to come to a country where the regulator isn't trying to put you out of business. So I'm hoping that message is getting across, and I'm hoping that the message is getting across too, that we do welcome people coming in to talk to us about what they're trying to do from a commercial perspective. And we do have statutory mandates, so we have to stick to our statutory mandates, but if we can work with people within those mandates to get to a place where they can do things that lead to long-term commercial viability, that is the goal. So I think that message is probably helpful, and I think it'll be a more powerful message when people see that there are people actually getting the kind of relief they need to be able to build their businesses here.
And how helpful is it that, it seems like the government at this point is all kind of rowing in the same direction, in the sense that the president is very much behind crypto in terms of his statements. You have the Presidential Working Group, you have the CFTC, which is very interested, the SEC as well. Does that inertia help? Is it useful?
Yeah, I think it's helpful to have the government working in the same direction. I think it's helpful to be working with people across agencies, because you can, the nature of this, the nature of anything that's regulated by financial regulators is that you're facing a lot of regulators at the state and federal level. So it's always helpful when those people are willing to talk to each other and willing to work with each other.
And in terms of the statements, I mean, we talked about the fluidity. We talked about the fact that certain aspects of crypto policy have been relatively ephemeral, and then the rulemaking that it may occur. I mean, are the statements that we've seen, are they the shape of the things to come in regard to rulemaking? Will a lot of them be rendered harder regulation and buying through that process?
Yeah, I mean, I think that's the goal, is to try to make those staff statements more permanent. So if people have criticisms, they should lob those in as soon as possible, so that we can incorporate that feedback in whatever we do at the commission level. But I think the goal, again, is to have things that are more difficult to reverse, so that people can rely more on them.
Amongst all of the guidance that has been provided, and there's been a lot of it. I mean, are there particular statements that you think should be made a priority? We should be focusing on in regard to thinking about the direction that the government's headed, about how they're thinking about cryptocurrencies, things along those lines?
Well, I mean, there are a couple things that I think we're focused on addressing, telling people when things are outside of our jurisdiction, so that whether it's people in the industry or people who are buying these products, they can plan for what kind of protection they're getting, right? So that, I think, is an important piece of it. I also think it's really important for us to engage with the difficult questions of what does it mean for an entity that we regulate to engage itself or help its customers interact with crypto. And so that means wrestling with questions around custody, for example. We put out recently a no action letter. The staff put out a no action letter on custody, but those questions are important. And then I think the tokenization issues are very real. So I put out a statement, which wasn't a staff statement, but it was a reminder to people that when you tokenize something, you've got to understand what it is, and you've got to tell people to whom you're selling it what it is. So I think those kind of issues around tokenization will demand a lot of our attention and be at the front of our agenda.
So in regard to the first point that you made, this question of jurisdiction, is there going to be more of a push to coordinate internationally, to coordinate more with state regulators, because of the fact that, in a lot of instances, these markets are transnational?
Yeah, I mean, and I think the discussion earlier this morning sort of was interesting on that point, and really it is important to note that each jurisdiction has its own. It shouldn't just be the assumption that some international regulators come together and they decide what the rules for the whole world are going to be. There's going to be jurisdictional diversity, and we should accept that. I always resent it when the assumption is that the international securities regulators will come up with recommendations, or they're sometimes written as if they're mandates to regulators in the U.S. about what they should be doing. I'm thinking, I'm not accountable to them. I'm accountable here in the U.S. And so I think we do have to recognize that there are differences. At the same time, in an area that's emerging like this, it is very helpful for us to work with our international colleagues and try to figure out what the problems they're seeing are, what the solutions they're trying are, which ones are working, which ones are not, so we can be very helpful to each other. I think we should explore things like mutual recognition, where if another country has the same objectives as we do, but they achieve them differently, we can recognize their framework, they can recognize ours. And then on the state level, I mean, these issues, I think, again, as today's discussions have showed, these issues really are very real to state regulators, and we need to make sure that we're working together with them. And we want to make sure that we're enabling them to do their jobs too, as we heard earlier. So I think it is important for us to work together on these issues and to try to be, thinking about things consistently. It's not a good framework if you have a great framework at the federal level and then the states are taking a wholly different approach. I think that will be very complicated for people to deal with.
Switching topics a little bit, one of the tensions that I've always found very interesting in regard to federal securities law is the one between investor choice and then investor protection. In terms of thinking about that, I mean, which standpoint makes sense in regard to thinking about cryptocurrencies? What's at stake in regard to both types of approaches?
Well, I don't think that they're inconsistent. I think investor choice is a key part of investor protection. So one of the easy things for a financial regulator to do is just to say no all the time to anything new, because that's the safest, seemingly safest thing to do, but it's actually allowing new competitors in who are, and frankly incumbents who are offering new products and services, making that very seamless, that process of coming into the industry seamless, or bringing a new product or service in seamless, that protects investors. Because if you just have a bunch of fat and happy incumbents, they will not end up serving investors well. They need to have that feeling of being chased by competitors who can offer something better, cheaper, and more more appropriate for investors. And so we want to keep that competitive dynamic up. I think, as we heard again earlier today, there's a lot of bad activity that's going on in the name of crypto, or has an element of crypto in it. And I think that is something that we need to take seriously, and we need to figure out how to protect people. A lot of that probably has to do with educating people. So I have, because the government is shut down, I've been answering the phones a lot. And I've been getting some interesting calls. And so some of them are, it's really very, it's very sad. It is the Indiana ad that we saw earlier today. I have had that basic scenario repeated to me, and it's people who, were really taken in by someone they believed to be real. And one woman, at the end of our phone call, she said, well, how do I know you're real? Because I'm telling her, don't. And in fact, she had fallen prey to a scheme that was done in my name. There's a Telegram profile out there. It looks very real. Someone screenshot it and sent it to me. And it's someone who's essentially offering to help people who have already been scammed to get their money back. And as you might imagine, it involves you putting more money in to get your money back. And so she's not the only one who's called me about it. Numerous people have told me they've been communicating with me on Telegram, and that I'm helping them get their money back. And so people are very, very crafty, and so we have to figure out a way to arm people so that they don't fall victim to this. But it's really difficult. And again, as this woman said, well, how do I know, Hester, the one I'm talking to now, that you're actually the real one, and that it's not the woman on Telegram, or it's probably not a woman, it's not the person on Telegram who's pretending to be you. And I said, well, come to DC and you can see me in the flesh. But I said, don't come now, because right now you can't afford to spend the money to do that. But I think this is it's a terrible problem. It's a very real problem, and we have to figure out what to do about it. Another guy called me and said, he asked me a question right up the front. He said, well, is this entity registered with you? And I said, well, I can't tell you that off the top of my head. And he said, then why am I talking to you? And I said, I don't know. I said, you don't have to talk to me. And he said, well, yeah, I don't see what the point is of talking to you. So anyway, I don't get very good. I don't get and give comfort to everyone who calls.
A somber note in terms of some of the things, but definitely admirable in the sense that, you know, a regulator who actually rolls up their sleeves and does the work is really impressive. My wife also makes me say that because she works for the federal government, but it's true nevertheless. So,
No, but it just illustrates that there is a need for, people have to be able to call someone and ask, can you give me a gut check on this? And we have to figure out a way to make that more efficient, and we have to figure out a way to broaden that reach.
yeah, which I agree. Wonderful point. Circling back a little bit, you know, it does seem like the Crypto Task Force, and with some of the statements that you've made, they're taking more of an investor choice model, meaning, you know, put these products out there, see if people want them. If they end up being great, that's great. If not, you know, there may be some harm that goes along with somebody choosing to buy them. What's animating that? I mean, is it pro-market? Is it pro-innovation? Is it pro-competition? You know, what sort of intuitions about how a market ought to function, you know, really is fueling that direction of things?
Well, I mean, markets really are about meeting people's needs, right? So if someone wants to be an entrepreneur, the reason that you want to be an entrepreneur is not so that you can make a lot of money. It really is, you've identified a problem and you cannot wait to solve that problem because you think it needs to be solved. And so then you may, as a result of that, if you're successful, you may get wealthy, and that's great, but the driving force always needs to be solving a problem. And so I think whether it's selling a crypto product or an exchange traded product, you know, you should be thinking about that. Now, we might disagree that people need some of these products, but I tend to approach things not from the perspective of the government ought to decide what people need and what people don't need, but people themselves who know their own circumstances, they know their own future prospects, they know their own portfolio, they know their own risk appetite, are much better at making those determinations. And so they should, you know, the market should be able to meet those needs or wants of theirs. But the flip side of that is that you're also responsible. If you make a terrible decision, you're responsible. And so that's not something that a lot of us are comfortable with in reality, because we do see people making decisions that we think are stupid. And we want to protect them from making stupid decisions. And so I think, you know, we live in a country where we really value freedom, and we entrust people to do all kinds of things with their lives, and frankly with their children's lives, and the government doesn't intervene because we prize freedom. And so what, again, I come back to is the best thing we can do is let the markets meet people's needs, but also try to educate people, which we need to start doing much younger. We should be starting in elementary school, and we should be educating people, giving them solid financial education so that they are well armed to be citizens in this free country that is the United States, where you do have to make these decisions for yourself and no one else is going to make those for you. And that's painful, right? Because it's much easier, again, for people who are regulatorily inclined just to say, you know what, I think an S&P 500 product is great for you and for you and for you and for you. And so look, we don't even need more than one product because the same thing works for everyone. And that can't be the right answer. And again, in a free country like this, we can't just come back to the point that we're going to make decisions for everyone else.
So building on that, you know, for cryptocurrencies to really reach their true potential, and it seems like they do have some real potential in terms of what they're going to offer society and what they are offering society. You know, is it possible to substantially limit fraud in this area, or is there going to be substantial fraud? Is substantial fraud just something that we're just going to have to suffer to allow that to occur?
I mean, anytime you let people have freedom, some people are going to use it in bad ways, right? And so I don't think we're giving people freedom to rip people off. That's illegal and it's always been illegal and should be illegal. I think some of the complexities of what we're talking about earlier about how a lot of this is actually happening across borders it's very difficult, and I think I just talked about financial education. We also need moral education. Someone else I know actually was he was targeted by someone, and so he decided he would talk to this person, and he said, what you're doing is really evil. And he said to her, why are you doing this? And she said, well, I've got a family to feed. I mean, he said, you might really want to look into another line of work. I don't think this was one of those people who was in a, locked away and forced to do this. It was her choice. And so, unfortunately, people often make bad moral choices. And so whether it's crypto or some other industry, whenever someone wants to rip someone off, they'll find some way to do it. We could outlaw crypto and people would still be ripped off. They'd find another way to do it. But I think that the message that is really important to give is that it's the one I was saying earlier. Identify a problem and come up with a solution to that problem. That's what you should be excited about doing. Unfortunately, because of the regulatory approach we took, it did not encourage that kind of building. Some people persisted and built useful things that people wanted. Many people did. But other people really said, well, okay, if they think we're all a bunch of, jokers and scammers, then we might as well do that. And so we, as regulators, actually encouraged bad behavior. So one thing we can do is stop encouraging bad behavior. And a second thing that we as regulators ought to do is have a little wonder too. There are brilliant people working with this technology to solve really difficult problems. And some of the problems that have plagued us as financial regulators have been around centralized financial intermediaries. And here along comes a technology that says, I have a solution. You don't have to do everything through a centralized financial intermediary anymore. We can help you to be able to do things directly, whether it's hold assets yourself or whether it's engage with your peers in transactions. And then you're protected from some of those really bad problems that can arise when you had to entrust your money to a central counterparty. And the reaction from people, many of whom have been very critical of central counterparties, has been to say, that's evil, that you would want to take out the big banks from the middle of these transactions. That's wrong. And I guess I just don't understand that. Again, I don't think we're going to disintermediate the whole financial system. People will want to deal with centralized intermediaries, and that is fine. But we as regulators ought to have open minds enough to be able to understand that this technology can solve some of the problems that we've had before. And so, yes, there are going to be bad things that happen in the name of crypto, but don't let that cloud your optimism that there can be some good things that come from technology as well.
So there's definitely been a sea change from the Biden administration, and certainly that extends to enforcement. What type of cases will the SEC still aggressively pursue? What are they likely to leave for the state regulators to go after? How are enforcement priorities going to be formulated, and how will they function?
Well, again, state regulators, you guys really need to be busy right now because we can't do anything right now. Very little. I mean, there's some limited enforcement activity that we can undertake now. But some people have said, well, this is great. Hester's in charge now at the SEC, which means we can do whatever we want. And I would caution people that that is actually not a very good way of approaching things, because I'm perfectly willing to use the enforcement tools that we have at the SEC to go after bad actors. I do think that it is not right for the SEC to bring enforcement actions when it has not spelled out the rules that it's enforcing, and so that's what we're trying to do now. But when those rules are in place, we expect people to abide by them. You don't get a free pass if you say you're just doing crypto stuff. And even now, I mean, fraud actions can continue, we look at each case on its facts and circumstances, so people need to be aware of that. But we also will continue to work with states. I mean, there's an important role there. As we heard, again, they're much closer to a lot of the bad activities that happen. They're much closer to the ground, so we'll continue to work with them, and we continue to work with our international counterparts there. I think that's another piece of international cooperation that's extremely important, is to try to work across borders, because so much of the bad activity is cross-border.
So, going along with one of the general themes of this discussion, obviously the Crypto Task Force, the SEC, is trying to create innovation, create experimentation. In terms of thinking about that, there have been a bunch of things that have been proposed and discussed. Regulatory sandboxes, for example, with the fourth roundtable, time passes, for example. Is any of that still being considered? Are there things that you've seen that worked well that you would like the SEC to be contemplating doing?
Yeah, and I should say we're not trying to necessarily create innovation, but maybe create the environment in which innovation can flourish. And I think part of that is, again, going back to this idea of letting people try to experiment to get to commercial viability. And so we are looking at things like sandboxes, a no action letter in some ways, which is basically the staff saying, if you adhere to these conditions, we will not recommend enforcement action. That can be a form of sandbox, an exemptive order that says, if you adhere to these conditions, you don't have to comply with this rule. Can be very helpful here, where sometimes the technology can actually take the place of the rule, of the prescriptive rule. So I think those have been successful in other areas, and I think could be very successful here. We've seen the development, for example, of alternative trading systems, ATSs, has happened under an exemptive regime, so something like that is valuable. We also have looked at foreign regulators' attempts to do sandboxes, and one of the things that I heard from some people who had tried to participate in one of these foreign regulator sandboxes is that it's so expensive even to go through the process of figuring out whether you're eligible for the sandbox, that it's not worth doing. And then that's especially true if you don't have a viable path for getting out of the sandbox and into a long-term regulatory environment. And so as we think about creating a sandbox, whether it's just an SEC sandbox, an SEC CFTC sandbox, or an SEC foreign regulatory jurisdiction sandbox, we want to think about ways that we can make sure that it's easy to get into the sandbox, or at least to figure out whether you want to be in the sandbox. And then it's also done with the idea that while there may be activity limitations at the beginning, the goal is to get to a long-term regulatory framework that is not regulatory arbitrage, but makes sense for the activity that you're trying to do. And you don't have to do your sandbox for 6 months, stop the activity, and then wait 3 years before you get a regulation, because that just doesn't work with the way businesses run. So I think we do think there's possibility there, but we encourage people who want to try things to come in and talk to us.
So let me ask something provocative. Ultimately, in terms of thinking about this, certainly yourself, Commissioner Ueda, Chair Atkins, have been pretty clear about the fact that they feel like this industry has been overregulated, that there ought to be room for innovation here, that we ought to see what markets have to say about these products, and that's important. Why not pursue an amnesty for everything type of program where the only thing that the SEC ends up pursuing is fraud, meaning let everybody play, even without the sandbox? Yeah,
I mean, we also have a statutory framework within which we operate, and so I think if you just said, yeah, anyone can do anything unless it's fraud, I mean, that might be a perfectly fine legislative framework to design, but it isn't what we have right now. And so I think you really need to try to do things within the regulatory framework that we have and make sure, I mean, while I do think that that new entrants are really important to holding incumbents' feet to the fire. You can't set up a system where new entrants get to play by one set of rules and incumbents have to play by the old set of rules. Now your response to that might be, well, that's fine, they can do that as well. But what does that mean? Does that mean that exchanges no longer have to file the filings that they're file their rules with us before they engage in them? I mean, again, that could be a fine system. It just isn't the one we have, and so I feel like we have to work within the system that we have.
It's sort of a flip side question. You know, what do you say to the folks who've waited for the green light, waited for permission rather than forgiveness, and maybe feel like they should have been more aggressive? You know, if they lost out because of their rules, and obviously you're somebody who believes in accountability because you answer the phone based on the stories you've told. You know, and maybe it wasn't your position that the SEC was taking, but you know, how do you deal with those people who feel like they've lost out because they've been overregulated so far?
No, I mean, there are real casualties of the approach that we took before. There are companies that could not survive because they didn't have funding to make it through, or we sued them and they were forced to stop offering a product or service that people actually wanted. And those are regulatory casualties. There are other companies, I think you're going to hear from one of them today, who was able to weather that storm. But, you know, the price of operating in a regulated, so now we as a regulator are trying to operate in good faith, but the price of operating in a very heavily regulated industry is that sometimes things take time. And so I think one of the things we heard at our SEC CFTC roundtable is it's a lot easier to get things to market on the CFTC side because they have a faster process than we have at the SEC. Now that's really driven by statute again, but maybe there's some learnings that we can take from how it has worked or not worked at other agencies to see maybe there are changes that need to be made there. But again, some of that is really driven by Congress, and so I feel like it is painful for a lot of people, and there are a lot of sad stories out there. But I don't think the answer is now just to say, well, you know, we're just going to open the doors and say you can do anything, unless Congress comes in and says we're changing the statute to allow that to happen.
So let me ask you this. I mean, there's been a lot of guidance, and you know, obviously yourself, Chair Atkins, have stated that you know a lot of digital assets are not securities, and I'd like to talk through that a little bit or explore that a bit. You know, obviously there have been statements that you know mining and staking, which Professor Hoffman talked about earlier, you know, in fact, do not yield a security, and I think that's at least part of why you know the SEC at this point is taking the position that Bitcoin, which uses mining, and Ether, which uses staking, are not securities. Can you talk a little bit about why that is?
I mean, I think those activities just really are not in the nature of securities activities. When we think about what the SEC is trying to regulate, we regulate capital raising. And so if you're mining a Bitcoin, I don't think that's a capital raising transaction. If you're staking ETH, even if you're using someone else administratively to help you do that, it's not the same thing as sort of a transaction in which you're entrusting your money to someone else to invest it for you, or to you know, through their efforts make it grow for you. So to me, that those factors don't really play in. I think the bigger issue is really around when someone is selling a token, what is happening in that transaction. And you could very well be selling a token which is not itself a security in a transaction that is a securities transaction. And I think that's why we've spent the last however many years, almost 10 years, talking about the Howey test, right? Because that does help us assess whether there's an investment contract. I think the complication is that we really have applied Howie in a very different way in this area than we have in other areas. And that's in part because crypto is something pretty new. And people are engaging in transactions that look more like capital raising transactions. And they're doing it using a token. But again, I think part of that is a function of the regulatory system we had in place. If we actually made it so that it wasn't a bad thing to be deemed to be a security, maybe more tokens would be securities. Maybe more people would design a token that actually gave you a share of the profits from a company. You know, we will see people tokenizing equities. So if we make it possible for you to have a token that is a security and not have it not be able to be offered to retail investors, then I think people will sort themselves, and tokens that should be securities will be securities, and tokens that aren't meant to be won't be. So part of it really does, I think, just turn on a good regulatory structure, and then people can think through what framework they want to fit in.
It seems like that answers a lot of questions, you know, with tokenized securities or ICOs, because they're capital raising, probably they can fall pretty easily on the security side of the line. With a lot of tokens, you're gonna have to run the Howey test. But let me ask you this, why has the SEC taken such a definitive statement on meme coins not being securities? You know, we know we have the guidance from the Division of Corporate Finance. It says that in some instances there might be exceptional cases, but generally these things are not going to be securities. Why so much action there?
I mean, at the time the staff issued that statement, a lot of people were issuing meme coins. And one of the frustrations that I had is that when we saw earlier instances of a lot of people doing things, the commission stayed silent. And it is better to tell people up front, hey, you're welcome to buy these meme coins, but don't buy them assuming that you're getting securities protections around them. Now again, you can take something that is not a security and you can sell it in a securities transaction, but a lot of these things are not. And I think sometimes people have this really expansive view of the SEC's jurisdiction, that every time someone sells something that goes up and then goes down, the SEC suddenly has authority over that. And, you know, that's great. That's enlarging my jurisdiction. I guess that I should really like that. But I mean, the reality is people buy things that go up and down all the time. Baseball cards, Beanie Babies. We can, you know, I don't even know the latest things that people buy that I think are kind of silly, but you know, they get very excited about them, and they you know, often end up not very excited about how much money they've spent and lost. That's just not my job.
So building on the investment contract definition, are you concerned about the fact that Congress has moved potentially to redefine the definition of what is an investment contract to facilitate freer markets? I mean, do you support the efforts? Yeah. What do you think the redefinition ought to take?
Well, I actually think redefinition of investment contract could be pretty helpful because I think we have struggled, and courts have struggled sometimes to figure out when to apply it. And I think in conjunction with redefining investment contract, you could also do something like designing a special regulatory regime to pull in things like pyramid schemes, which we have tended to use the Howey test and investment contract analysis to go after, but there might be a better way to do that. So I think any kind of redefinition of investment contract, or more precise definition of it, should be done very carefully. Because we want to make sure that we capture transactions in which I give my money to someone else, reliant solely on that person's efforts to do the work, and with the expectation of profits from that transaction. We should be capturing that, and that is what the investment contract element of the securities test is designed to capture. So as Congress thinks about it, they should make sure that we're able to, and again, I think state regulators have an interest in this too, that we're able to go after those kinds of capital raising transactions no matter what they're called. And so I do think more definition could help, but it has to be done carefully.
Let's switch topics a little bit. What are you most proud of in your many years with the SEC? I mean, obviously you've been with the SEC since 2018. What's your legacy?
Well, I've hired great people. One of them is Landon Zinda, who was supposed to be here today, but he couldn't come because of the shutdown. So I think that is what I'm most proud of. But I also just will say that given the change that we've had at the SEC, at the commission level, it has empowered the staff to be really engaged on these issues. And these are really difficult issues. Crypto touches a whole range of things the SEC does. And I have been so impressed at the ability of the staff, when given authority from the commission, to engage with people on these issues, to wrestle through these issues. And that is something that I think should encourage everyone, that there are a lot of smart, hardworking people applying their minds to these problems.
Certainly not done yet. There's a lot of runway ahead. There's still time, certainly in terms of your career, but even in terms of your time at the SEC. What else do you want to do in regard to crypto and otherwise before you ride off into the sunset?
Well, I'd like to get some rules on the books, or at least out there in proposal form, and I'd like to see some. So the chairman talks a lot about the innovation exemption, and I'd like to see us give some more definition around what that looks like, and actually have people see the innovation exemption at work.
Building on that, I mean, a lot of what we talked about today, and in terms of your speeches and the things that are out there in the world, seem to suggest that the SEC ought to be doing less in regard to crypto. Meaning, other things that potentially it could be concentrating on, other things out there in the world. There's been such an emphasis placed on it that I know a lot of your time, which is very valuable, is taken up with it. If things move away from the SEC in regard to enforcing the regulations surrounding crypto, what would you like to see the SEC focus on, prioritize?
Well, there are a lot of things. I mean, bread and butter rulemakings are always tug on my heartstrings. So whether it's getting our record-keeping rules modernized, making it easier for financial firms to communicate with investors in ways those investors actually can process that information and apply it to their own circumstances, i.e. we need to move away from paper-based rules because that's just not how investors think about things. And then, I think some issues will be teed up well by crypto, but there are areas we need to spend more time thinking about. Transfer agents is one. That rule has needed modernization for a long time. It may be crypto that forces us to do that. Thinking about modernizing the investment advisor custody rules. Again, crypto may be the catalyst for us to really do that and do that well, but I'd like to see that happen. And then one issue that's constantly on our minds is what can we do to make the public markets more attractive for more companies earlier in their lives. And I think that will require us to revisit some of our rule book, make sure that it's well calibrated. So there's certainly a lot that we can do that doesn't necessarily have to do with crypto.
Well, I do want to leave some time for questions, but thanks so far for a great discussion. Why don't we open it up to questions?
Commissioner, thank you for coming to Ohio, first of all. When I received the invitation to speak, thanks again for that. I thought, well, this is curious. Why is the entirety of the Ohio Securities Conference dedicated to things that are not securities? And I puzzled on that for a little bit. And I thought one of the clear sort of areas of overlap is when it comes to tokenization, and specifically tokenized securities. I absolutely am of the mindset that a tokenized security does not stop being a security simply because it's issued on a blockchain. But that in itself, because of the differences in the architecture of the traditional securities markets and blockchains, raises a lot of really interesting questions. And so from my perspective, my company Ledger absolutely does not in any way want to be involved in the securities business. But if somebody were to issue a security, a share of stock or something, let's say according to the ERC-20 standard, those securities would immediately be compatible with our devices and our software, and there would be absolutely nothing that we could do about that. And so, I'm just sort of curious how you or the commission more broadly is thinking about some of these really interesting technical issues when we do have direct overlaps between securities and blockchain architecture.
Yeah, I mean, I think tokenization raises all sorts of interesting questions, and one of them is the one that you're raising, which is that people can actually once again possess their own securities, and they can do with them what they want, and that raises a number of challenges under the securities laws, UCC issues. We have to think about all these things. How does that interact with Reg NMS? If it's a Reg NMS security, and so I think we're trying to wrestle through all of that now, but it's great for any budding securities lawyers. There are a lot of interesting issues to write your law review notes on.
Yeah, thank you again for coming. You're so generous with your time, and I'm constantly impressed by how many smart people are so generous with their time. So you gave us a great model of kind of how to be generous, and so I just want to thank you. When my earlier conversation with Seth, I referred to the quote that if you come across a gate, you should never take it down, because nobody builds a gate for no reason. So first, a two-part question. First is, do you think that analogy applies to where we are now? Are we taking down bridges, or are we moving into new land? And the second part is, for the bridges that are taken down, assuming that we are, how confident are you that they were built for no reason, or that the reason no longer exists?
Well, first of all, thank you for those kind comments. And second, I did think that quote was really interesting. I had to think about that, and still have to think about that some more. Like, yeah, if you do see a fence, should you assume that there's a reason it's standing there? But I think that the technology that we have, as technology develops, sometimes you don't need the fence anymore. Maybe the fence comes down because you put an invisible fence in, and so you're actually not seeing the fence, but there's still a fence there. Or maybe you've diverted, or you've added alligators to the stream that's around your property, so you don't need it anymore. Or you got a big dog. So there could be reasons why you can take that fence down, and so I think we have to confront, are there actual reasons? But at the same point, we also have to think about whether the fence is there for a reason, and whether maybe there is a reason that, this issue comes up with custody, right? Custody of assets. It's really difficult in the crypto space because a lot of investment advisors actually cannot find a good custodian to custody the crypto assets for them. So in and maybe they need to keep those assets in their own custody so that they can manage them in a way that's consistent with their fiduciary duty to their investors. And so do those considerations outweigh the considerations that led us to have a custody rule in the first place? They may. But I think we also need to remember that we had the custody rule in the first place because sometimes when advisors have their investors' assets, they steal them or they're careless with them. And so we're going to have a way to counteract that concern. And so, yes, we should always be thinking about why was this rule put in place? And then if we're going to eliminate it, we better make sure there's some other way. Now, again, blockchain is interesting because it allows much greater transparency. It allows us to do things in ways that, there is really decentralized control, so no one is making the decision not to give a loan to a particular person because he doesn't like that particular person, even though that particular person has the same criteria, meets all the criteria for getting the loan. So maybe a decentralized technology actually gets rid of those kinds of concerns that you might otherwise have. But you have to think about it on a rule-by-rule basis.
Has the change in the Supreme Court's decision in changing the way courts evaluate administrative regulations from Chevron to Loper-Bright, I'm just wondering, has that change had an effect on how you do your job, on how the SEC goes about any of its internal processes? I mean, from the outside, we think it's a big deal, but I just wonder, for you, does it actually alter how you go about doing the things you do?
Well, it's a good question, and I think that over time we'll have a chance to see whether, how that plays out. But the SEC had a prior run-in with the courts, and that was around our economic analysis. Courts basically did not like how we were doing economic analysis or not doing it. And so it caused us to really take seriously that process of economic analysis. I'm not saying we always do it well, but we started to put a lot more resources into it. We created a whole division of economists to help us do that. And so I view the Loper-Bright moment as a moment for us to think about whether we're doing our statutory analysis correct. And over the, you mentioned my dissents, and many of my dissents tied to a concern that we didn't actually have authority to do what we were trying to do. And sometimes we were sued and the courts agreed that we didn't have the authority to do what we were trying to do. So it's not bad for us to really sit back and think as we're adopting a rule, do we actually have the authority to do this? And I guess I have a little bit of maybe personal baggage on this point, because I worked on a rule many years ago when I was on the staff at the SEC that now I look back at it and I don't actually think we had the authority to adopt that rule under the provision, the statutory provision we adopted it. And so, why didn't I think about that at the time, right? Why wasn't I more critical? And so I think something like Loper-Bright can help us to be more careful in really tying what we're doing to actual statutory authority to do it.
I think now is probably a good time to break. I want to thank you.
Question?
Oh, we have one more? One last question.
Now I'm the guy who kept everybody from the break.
The guy who didn't see you, so it's fine.
I apologize. I have to say, you mentioned your staff and their inability to come here today. For those of you who haven't had experience recently during a shutdown, trying your level best to engage with folks at the SEC, the staff really have done an admirable job under very trying circumstances. So I wanted to just thank you and thank them on behalf of the industry and others who are engaging as best we can.
I'll pass that along when I'm willing to talk, when I'm able to talk.
When you're able to talk to Can I ask, you also alluded to your own experience as a staff member earlier in your career. What's one thing about that experience or what you observed with your staff that maybe not enough of us who are focused on our problems, day in and day out, don't appreciate about the challenges that staff face in carrying out their responsibilities?
I think, it's that staff operate within a bureaucracy, and so even if an individual staff member might think something is a good idea, there are a lot of levels that you have to go through. And Chairman Atkins is not a big fan of, complex hierarchies, and so I think he will try to break that down. But I think it's the nature of a bureaucracy that there's going to be that issue, and I think a lot of people experience that firsthand when they were trying to get approval for something, and this was when there wasn't direct direction from the commission that we wanted stuff to get through, right? And so they would get batted from one division to the next and have to get approval from one division, then go to the next, and then go back to the first, and then go to FINRA and then come back, and you feel like you're being ping-ponged around. And so I think to the extent we can prevent that from happening, we would like to, but there's going to be some level of that happens in a complex bureaucratic system.
Well, we're at time. Thank you for a very
Thank you all very much.